Thank you, Tony. Right, thank you for the introduction, Tony. I'm Stephen Watts here on behalf of a company called AML-CC, the Anti-Money Laundering Compliance Company. I've got just under an hour to talk you through the money laundering regulations and what you should be doing to be compliant. I've very much pitched this presentation on a practical level, so hopefully you'll go away and the 8 steps you can all quickly adopt when you go back into practice. Okay, I will start though by giving you a very brief background to the legislation, what the main changes were since the last legislation was 2007. Okay, just one thing as well, if you've got any questions, if you can hold them till the end, because there is a natural flow to the presentation, so I'll allow 15-20 minutes at the end for any questions. Okay. So a bit of background, what is money laundering? The relevant legislation is covered in 3 pieces: Proceeds of Crime Act 2002, the Terrorism Act 2000, and then the Money Laundering Regulations 2007. Okay? It was the Money Laundering Regulations 2007 which came into force on the 15th of December 2007. Okay? So it's been a few years since they've been in force. The legal definition, as you can read it for yourselves there, concealing, disguising, converting, transferring or removing criminal property. Okay? I think most people, when you mention money laundering, they think of maybe, I don't know, Al Capone figures, maybe think of drug trafficking, financing of terrorism, etc. And you probably think you're not going to come across a situation which needs to be reported. Okay? But money laundering can also be defined as tax evasion. Okay? There needs to be 2 things for a money laundering offence to happen. Firstly, there needs to be a criminal act, which is fraud, which is what tax evasion is. Okay? And secondly, there needs to be proceeds of that crime. Okay? So again, if someone's engaged in tax evasion, the proceeds would be the savings of tax. Okay? So that's more likely what you're going to come across. You're not necessarily going to come across a situation like drug trafficking or financing of terrorism, etc., etc. That's more complex cases. But money laundering can be, just a single act where someone's in proceeds of their own crime, which is what tax evasion is. Okay, so that's why it is relevant to yourselves, and that's why you may come across a situation which does need to be reported. Why are you here today? Because you are in the last group, accountancy service providers. Okay, there's quite a few different sectors which the money laundering regulations 2007 apply to. One of them is ASPs. Okay, so what has changed since the previous legislation? 2 key areas have changed. Firstly, is to do with customer due diligence, okay, and client identification procedures. I'll go through this in a lot more detail later on. And the second main change was the Treasury gave supervisory status to 22 professional bodies. Okay, so 22 professional bodies have now supervisory status, so they now have a responsibility to provide information, guidance, support to their members, as well as also supervise their members to make sure they are being compliant. Okay, so 8 steps to compliance. The first step should be quite a simple step. You need to appoint someone in your office to be the MLRO, okay, Money Laundering Reporting Officer. Okay, that should already been done by now, but it hasn't. You just need to make sure you do it when you get back in the office. The important thing is make sure everyone, if you've got some staff, make sure the staff know who the MLRO is. Okay, so make sure they do know. It's an obvious thing, but make sure everyone in the office does know who the MLRO is. So just if you do have a visit and someone asks a member of staff who's the MLRO, and yeah. It does carry significant responsibility. So although the regulations don't state there's a prescribed level of seniority, the guidance does say that it should be someone in a senior position. Okay, because the sort of things which the MLRO will have to do, they'll have to consider internal reports. Okay, so if you have staff members in the office and they come across a situation which needs reporting, they won't report that straight to Sokka, the Serious Organised Crime Agency. They will report that to the MLRO. And it's the MLRO's responsibility then to decide whether a report needs to be then made onto Sokka. Okay, so it's quite a significant responsibility. Also, once that report has been made to Sokka, or if the report has been made to Sokka, then the MLRO will be responsible for any contact or any follow-on points which Sokka require. Okay, so there will be the point of contact. Okay. Now, the MLRO may also take responsibility for devising the internal training for their business, for their practice, and the other staff members. They may also have input into designing and implementing the firm's internal control systems. Okay? And it's also recommended that if you are in an office where there's 3 or 4 other staff, you've got someone else who's also senior, it may be also a good idea to appoint someone as a DM, LRO, Deputy Money Laundering Officer. Okay, just to cover periods of absence, whether you're on annual leave or whether you're on a client's all day, etc. Okay, so that's the first thing, appoint someone as the MLRO. Okay. Second step to compliance is to have a compliance manual within the office. Okay. It's not required legally, but certainly it's best practice to have a compliance manual. Something where yourself and staff members can go to as a reference, for a reference tool. Okay. It can be manual, it can be online, it can whatever form you want, but just somewhere where people can go to should they have a query regarding money laundering, the money laundering regulations. Important that if you have a compliance manual, even if you don't have a compliance manual, you do need a policy statement. Okay, so it's advisable to have a statement which clearly sets out what your policies are on money laundering. Okay, what are your policies on training? Do all staff get trained 6 monthly, 12 monthly, biannually? Okay, what are your policies regarding identification procedures? Do you rely on passports? Have you embraced electronic verification? Okay, so these are all sort of things which perhaps should be in the policy statement within the manual. Okay, if you do have a manual and you do have a policy statement, just pass it around the office, make sure everyone signs it. Okay, just so you've got something to say that everyone's aware there is a policy statement and everyone's happy that they know where to go should they need additional information. Now, the actual compliance manual, the information could just be taken from your supervisory body's website, or some supervisory bodies provide quite good information, quite good guidance, so that can form part of your manual. But there should be something where people can go to. That's the important point. Okay, so that's the second thing was to have a compliance manual. The third step to compliance is training. Okay, there is a requirement within the regulations to train all relevant employees. Okay, the regulations don't tell you what a relevant employee is, but the CCABE Guidance, which was issued by all the professional bodies, it suggests that anyone who's client-facing. Okay, so anyone who deals with, if it's a tax return, maybe entering the data for a tax return, bookkeeping, if you run a payroll, and whoever runs a payroll, okay, whoever's involved, certainly whoever's involved in putting together a set of working papers, they are all client-facing, so they would all be required to be trained under the money laundering regulations. Okay, very important. The legislation also says that training should be given regularly, but again, it's not very helpful. It doesn't say how long. But the guidance suggests that at least on an annual basis. Okay, so at least every 12 months, you should update your training, or more frequently, if there are changes in the legislation or maybe case law. Okay. That's the third step. The fourth step and the fifth step are both to do with customer due diligence, okay, which is one of the big changes of the regulations. Okay, so the fourth step is it's to do with verification of clients. Okay, what you have to do now is you have to identify and verify your clients. Okay, which wasn't a change from 2003 regulation. That's what you had to do then. So you should have been taking passports, driving licenses, etc. back in 2003. So what you need to do, identify clients. That can be straightforward. Okay, you have someone come through the office, what's your name, Joe Bloggs, you've identified him. Okay, the challenge now is to verify that information. Okay, and what you can do, you can verify it either electronically or manually or a combination of both. Okay, so the 2007 regulations approved the use of electronic verifications as an acceptable form of verifying clients. Okay, which was a change from the 2003 regs. Okay, so you don't necessarily have to always rely on a passport. You may just adopt a passport or just do electronic or do a combination of both. Okay. Some firms adopt the belt and braces approach. They ask for a passport, driving licence, utility bill, just because most people nowadays do expect to bring that in when they go to see a new accountant, solicitor, bank, etc. And in addition to that, they also do an electronic check on the client. Okay. So what you need to do, identify and verify the clients. If it's a limited company, so you need to bear in mind that if you act for someone who is also a director of a limited company, there's two clients there. Firstly, the client who you're going to be preparing, presumably, the self-assessment return for. And secondly, the company who you're going to be preparing the accounts for. Okay, so you also need to identify the company. Okay, so again, straightforward, Joe Bloggs, what's your company name? Joe Bloggs Limited. Easy. You then need to verify that information, to verify that that company does exist. Very easy, go to company's house, print off a company details page, job done. If you want, you can go one step further, print off an annual return, maybe print off a credit report, anything you need just to prove that that company is in existence. Okay? The way you need to look at verification procedures is every additional piece of information you gather on a client means there's less risk that that client is not who they say they are, if that makes sense. Okay? So the more the better, really. Okay? Something else you have to do now under the 2007 regulations, you have to identify the beneficial owners of your clients. Okay, so this is a new term, beneficial owners. Now, we'll just go on a few slides for beneficial owners. Here we are. So, a beneficial owner of a limited company would be any individual who owns or controls more than 25% of the shares or has more than 25% of the voting rights. Okay? If it's a partnership, it's any individual who controls or is entitled to more than 25% of the capital or profits. If you act for any charities, it's usually the trustees who are beneficial owners. If it's a trust, it's any individual who is entitled to a specified interest in at least 25% of the capital. Or if you're acting for a deceased person, then it's usually the executor or the administrator of the estate. Okay, that's something you need to be aware of. So you're not just identifying and verifying the actual clients, you also need to identify the beneficial owners. And clearly the key percentage is 25%. Okay? Now, the chances are most of your clients, I'm assuming is maybe family concerns, maybe directors are also shareholders. So if that's the case, then the directors may be husband and wife 50-50. Okay? Chances are you're also probably doing the tax returns for both, so you're covered on that score. But just be wary of any outside shareholders who aren't directors. Okay? I don't think there's anything inherently sinister about beneficial owners. I think the regulations are just trying to get the point across that you have to understand where the control lies in one of your clients. Okay? Is there a shadowy figure in the background who's actually exerting all the control, putting the money in, but isn't actually on the front who you actually deal with? Okay, so that's why you need an understanding of who the beneficial owners are. You don't necessarily have to verify the beneficial owners. Okay, you just need to identify them. Okay, so that's why an annual return is useful, because that's all the information on an annual return. If you feel a client is high risk, and I'll go through that on the next couple of slides, you may take the view that you should then also verify them beneficial owners. Okay. So that's the fourth step. You just need to be aware that you identify and verify your clients, and also the key is identify beneficial owners. Okay. The fifth step, which is also in relation to customer due diligence, is risk-based approach. Okay, this is a key to the changes in the regulations. Okay, you have to be adopting a risk-based approach to your customer due diligence, CDD. Okay. So what is a risk-based approach? Essentially, it's just making sure you ask yourself certain questions and have an understanding of who you're acting for. Okay, because you need to assess what level of risk a client presents to you of them committing a money laundering offence, okay? And you're not going to know unless you go through certain questions, okay? So you need to understand the risk a client poses. You also, general things which hopefully you try to gather at the initial meeting anyway, in terms of understanding what the business does, making sure you have a good understanding of where the sources of finance are coming from, who the controlling parties are. Okay, these are sort of things as expected you should know. Okay. Other things you could ask yourself. Just find out if it's a cash-based business. Okay. Now, a cash-based business. I'm not suggesting all cash-based businesses are going to commit a money laundering offence, but the opportunity is there for them to do so, more so than if it wasn't a cash-based business. Okay. So if it's a cash-based business, just be aware of that. Okay. It may well be that cash-based businesses are high risk. If so, just make sure you mitigate. You take steps to mitigate against that high risk. Okay, so maybe when you're putting together a cash control, petty cash control, make sure it all balances, make sure any cash withdrawings, cash drawings or cash in, whatever cash has been introduced, make sure you understand exactly where it's all coming from. Okay, so that's all it means. It doesn't mean if you've got a cash-based business, if you've got a hairdresser's, you've got a pub or you've got a restaurant, it doesn't mean you've got to kick them out the door. It just means you've got to be prepared to maybe do additional checks when you put together the set of working papers. Okay, just to make sure you ask the right questions at the end of the year meeting. Okay, so that's what it means. Okay, so you risk assess a client, and if the client comes back low risk, normal risk or high risk, you just take the appropriate steps to mitigate against that. Okay? Other factors which could indicate high risk would be, have they been subject to previous revenue and customs inquiries for overstating expenses and declaring income, etc.? Have they come to you and the purpose of a business is just not clear? You just don't think there's any economic rationale for them to do what they're doing? Are they just trying to front that business to introduce funds from elsewhere? Okay? Have they jumped from accountant to accountant? Have they had 6 accountants in the last couple of years, whatever? You know, are they trying to put something through the books which these accountants aren't particularly comfortable with, which is why they keep going accountant to accountant? Okay, so these are sort of things you just need to have an awareness of, which would, not in every case, but may suggest generally that there's something to hide and there may be more chance of them committing money laundering offence. Okay? So just in summary of CDD, I mean, it's quite a complex topic, but I mean, in summary, what you need to be doing is identify and verify your client's identity, identify the beneficial owners, and also obtain information on the purposes of the business and also what they want you to do. Okay, so just try and ascertain as much information as you can about initial client meeting. Okay, now a lot of them things I've just gone through, you're probably going to be that's sort of questions you ask yourself anyway, just trying to get an understanding of any new client. So it may well be that you have information on your file already, which would help you towards your customer due diligence. Okay, but this is a key part of the regulations, customer due diligence. Okay, and risk-based approach. Okay, now what I will say, the very nature of a risk-based approach, and the guidance accepts this, is it's not going to be 100% foolproof. Okay, there are going to be some clients who maybe do commit a money laundering offence, but you've maybe assessed them as low risk. Okay, so it's, you know, but look, the challenge is you have to prove you've got systems in place to assess the level of risk, and if someone slips through the net, at least you've got something to fall back and say, well, actually, I did my own risk assessment based on the information I was given. I felt he was low risk. Okay, so you need that in place, otherwise you may have no defence if someone does commit money laundering offence and you haven't got any risk assessments to prove it. You did actually go through that process. Okay. The 6th step is to do with reporting. Okay. You have to have clear reporting procedures in place. Okay. Both for internal reports, and by internal reports I'm referring to staff reports to the MLRO, and also external reports, which are reports which the MLRO would then make to Sokka, the Serious Organised Crime Agency. Okay. External reports are also referred to as SARs, Suspicious Activity Reports. Okay. So you need to have clear reporting procedures in place, and importantly, staff need to be aware of them reporting procedures. Okay. So if you have staff and they come across a situation which needs to be reported, are they comfortable? Do they know what they have to do, who they have to go to? Do they send you an email? Do they come in and see you in the office? Do they put something in writing? How do they do it? Okay, so very, very important to have clear reporting procedures in place. So what must we report? The regulations require us to report any knowledge or suspicions of money laundering to the MLRO. Okay, so if any of your staff members, they have a legal obligation, if they come across a situation which gives them knowledge or suspicion, they have to make a report to the MLRO. Okay? Once that individual has made that report to the MLRO, it's up to them, the MLRO, to decide whether a subsequent report is then made onto Sokka. Okay, so the ball is firmly in the court of the MLRO. Okay? They also have to report if they have reasonable grounds for suspicion. So it's not just knowledge or suspicion, it's reasonable grounds for suspicion. And there are penalties for failing to report. Okay? Now the downside of all this is it talks about knowledge, suspicion, reasonable grounds, but it's not defined in the legislation, so no one actually knows what suspicion is or what reasonable grounds is for suspicion. What we will say is knowledge is clearly something that is case, so there may be some factual element to it. Okay, so there's facts which suggest it is knowledge. Okay, suspicion it's more than speculation. Okay, so you got knowledge here, speculation here, suspicion is, I suppose, in between. Okay, that's how you're going to look at it. Okay, but there's been no case law so far to support what reasonable grounds or what suspicion is. Okay, but certainly, you know, idle gossip or speculation would not be suspicion. Okay, so a general assumption that, I don't know, all scrap dealers are criminals, therefore I'm going to report my scrap. That's just speculative. That doesn't need reporting. Okay. Same with the example I said before about cash-based businesses. You know, just because someone's a cash-based business doesn't necessarily mean they're going to underdeclare their take-ins or overstate their profits, expenses, etc. You need some evidence to substantiate your report. Okay. What you should ask yourself, I've mentioned here that reasonable grounds has not yet been tested, but what you should ask yourself is, would an honest and reasonable person in your position, i.e. with your experience, your background, your qualification, your knowledge of a client, would they have had knowledge that money laundering was taking place? Okay, so you can't just turn a blind eye. You know, you need to ask yourself, you know, should you really make that report? Okay. I've said here on this slide, if unsure at the bottom, if unsure, you may just want to report for suspicion. Okay. That tends to split people. I mean, some people say, OK, I just want to make a report just to cover my own backside in terms of the money laundering regulations. But other people say, well, I've got this duty to my client. I don't really want to just report them willy-nilly. It might get them in trouble with it. It doesn't necessarily need to, you see. So it's very much depends on what your risk profile is, I suppose. You know, so, you know, if you have got knowledge of suspicion, you should make that report. If you're not sure whether you make a report or not, if you decide not to, you need to document your reasons for not doing so. Okay, very important. If you decide not to make a report, so if your staff member or a staff member has made a report to yourselves, if you are MLROs, and you decide not to make that report onto Sokka, the very least you need to do is document your reasons for not doing so. Okay, because when you have an inspection, they will want to see all internal reports made, and if them reports haven't then been passed on to Sokka, you should have good reason for not doing so. Okay. What I've also said here is, you don't need to, I suppose you don't need to be Sherlock Holmes and do your own investigation work. You just need to report what comes across your desk. Okay, so you don't need to carry out any further investigations or try and identify the crime or try and go after the proceeds. That's not, you know, that's not what it's about. You just need to report what comes, what's brought to your attention. Okay. I'll just point out there is an offence of tipping off. Okay, so if you do decide to make a report or decide not to make a report, either way, you shouldn't tell the client. Okay, don't tell. There is an offence of tipping off, so do not tell your client that you're even considering making a report. Okay, obviously there may be circumstances where you need to ask the odd question, but just be wary of this tipping off offence. Okay. Now, just assuming that you have received an internal report from your staff member, and you decide then to make that report onto Sokka, that report needs to be done as soon as possible. Okay? There's a variety of methods which you can submit a report to Sokka. By far the most efficient and least time-consuming method is through their website. Okay? So if you haven't already done so, you need to register with Sokka website, sokka.gov.uk. There's a part, I think on the top part, it says SAR Online, which is Suspicious Activity Report Online. That's where you need to click on. Register your details. You get your own logins. And once you've got your logins, if you're then in a position where you need to make a report straight away, you don't need to go through a registration process. Okay? That's by far the easiest way. And the majority of reports which are submitted to Sokka are submitted through, it's called SAR Online, which is online. Okay? One of the benefits of doing so online is when you make a report, you automatically get sent an acknowledgement by Sokka. So you then know that your job's done and it's up to them to decide what to do with that report. Okay? Just some information on Sokka. In terms of the number of reports submitted to Sokka, for the year end 30th of September 2011, which is the last set of figures which they've produced, 248,000 reports were made to Sokka. Not too far off the previous year, 241. Okay, 6,000 came from accountants, which is, I think that's high or low really. The majority, any idea who the majority, what sector the majority would come from? Banks, yeah. About 70% I think it was for banks. Which doesn't necessarily surprise you, bear in mind the real-time information, real-time access they have to their clients' information. Whereas yourselves, you probably may see your clients monthly, quarterly, or even just annually. Okay, so that suggests. So I mean, I don't know whether that figure is low or whether it's high or whether it's just what Sokka expect. But Encouraging from these figures is that almost 3,000 new registrations on the SAR online, which is what what you need to do to register online and submit a report online. And of them 3,000, 33% came from accountants. So it does suggest that accountants are at least more aware of the regulations. They are aware that if they do need to make a report, the best way to do it is SAR online. Okay, further information on the website there. I've just mentioned briefly confidentiality. I mean, clearly these reports which you're going to submit are top secret, highly confidential, and Sokka do appreciate that. The government, Sokka, the Treasury do appreciate that. In the last report, I think as an article in the last magazine, I think it shows that there were only a handful of complaints regarding breaches of confidentiality. Okay, so that suggests that they are quite hot on it, and which they need to be, because what you don't want is your client ending up knocking on your door and say, how did these guys hear about myself, etc., etc. Okay, so that's very important, and it's worth pointing out that Sokka do appreciate and acknowledge that, and it looks like they are acting on that as well. The seventh step to compliance is to do with record keeping. Okay, there is a requirement within the regulations. You have to be able to prove your compliance to the regulations. Okay, and the only way you can do that is by keeping records. Okay, so you have to be keeping records of your training, who's carried out the training, when it was, risk assessments, okay, whatever risk assessment you've done on your clients, whether it's manual, online, any internal reports which have been made, just make sure you keep them for your supervisory body to view if they come and inspect you, and indeed any external reports, any SARs which have been made to Sokka. Okay, record keeping can be manual or online, electronic. I've said here that the records do need to be kept for 5 years. Okay, so just bear that in mind. Okay. And the eighth step to compliance, you need to be supervised. Okay, the 2007 regulations required you to be supervised with a regulatory body. Okay, there's 22 which were provided with supervisory status by the Treasury. So if you're a member of one of the 22, they would be your supervisory body. If you're not a member of M22, you'd be supervised by Revenue and Customs. Okay? So you have to be supervised. So if you haven't already done so, you need to contact your professional body and make sure they know that you want them to be your supervisory body. There are fines, etc., if you're not supervised. And the key date here was 3 years ago now, 1st of January 2009. That's when you had to be supervised by. Okay, so you haven't done so now, it's something you need to do. Okay? If you do want to read up on this, there's quite a good document actually, the CCABE Guidance, which is a consultative committee of accounting bodies. It's quite a good document, 95 pages long, quite useful and quite easy, it's quite easy to read as well. OFT, HMRC, or even your compliance department. If you need further information, then speak to your compliance officer at your supervisory body. Okay, there's quite a lot of good information online, depending on what professional body you're part of. So that's always a good source of information. But just summarise what you should be doing. Make sure someone in the office is the MLRO. Have a compliance manual, which clearly sets out your policies and procedures. Include a policy statement within that. Make sure you're training, make sure you have training, make sure it's updated on at least an annual basis. Identify, verify your clients, not forgetting beneficial owners. Adopt a risk-based approach to your customer due diligence. Okay, so make sure you're asking yourself them questions which I went through. Make sure you have clear reporting procedures in place. Keep records of all the above so you can prove compliance. And make sure you're supervised. Okay? So if you adopt them 8 steps, you'll certainly be on the right track to compliance. And hopefully you'll see that hopefully it doesn't necessarily have to be too time consuming. You know, a lot of the customer due diligence work you're probably already doing. You've probably got information, say, gathered at the initial meeting. You may already have information on your working papers file, your tax and correspondence file, your audit files. Okay, there might be sufficient information already on them to help you towards your customer due diligence. Okay. If you've got existing clients who you've acted for a number of years and you haven't done any due diligence on them recently, because customer due diligence has to be done for new relationships and also on an ongoing basis should something change. So I'll give you an example. If you had a client who suddenly has a new source of income, changes his business activity, then it would be a good opportunity then to revisit the customer due diligence. Okay? But if you've been active for a number of clients for a number of years, then like I said before, you may have sufficient information already on the file to show that you know them inside out and you know that they're probably low risk. If that's the case, all you need to do is list them clients and just make that statement that I've acted for these clients for a number of years, I feel there's sufficient information on whatever file to suggest they're low risk. And that could be your risk assessment for a number of clients. You don't need to go back to every single client file and or assess them if you haven't already done so in the last few years. Okay? But you need to have something on file because people will look for, or the compliance officers will look for, what customer due diligence you have carried out. Okay, it's a key part of regulations. I'll give you a brief update on inspections. We've got quite a while yet. So they are being stepped up. What you have to appreciate is these regulations have been in place since 2007. Okay, so the first 18 months, 2 years, there may have been more of a laid-back approach to inspections. Okay, but certainly the Treasury now are expecting supervisory bodies to step up their visits and their inspections. Okay? Every year, the 22 supervisory bodies have to submit a report to the Treasury on what they've done regarding providing information, support, guidance to their members, but more importantly, what they've done in terms of supervising their members to making sure they've been compliant. Okay, so you have to actually submit a report to the Treasury. Okay, so there is not necessarily a pressure, but there's certainly a requirement that they are carrying out a certain, although there's no required level, Treasury needs to be satisfied that their supervisory bodies are doing something in terms of making sure their members are compliant. Okay? I've mentioned here the period of grace is clearly over. I mean, we work with a number of supervisory bodies, and certainly what we gather from them is there was a period of grace in the first couple of years, like I said. But now when they go have an inspection visit, because the regulations have been in place for over 4 years now, you know, there is an expectation that you guys should know enough about them to be compliant, or certainly show you are on the right track to compliance. Okay, and like I said in my presentation, in the 8 steps, you know, you don't necessarily have to do an awful lot to show them that you are being compliant. Okay, the worst thing that can happen is someone to come and have a look at if one of your supervisory bodies to come and inspect you, and no one knows who the MLRO is. You've got no training, you've got no risk assessments, you've got no passports. You know, that's what you want to try and avoid. Okay, so if you can get these things in place as soon as possible, as soon as you can, and at least then you've got something to show them. And also there's an intent there. You can prove that you have got an intent to actually be compliant. Okay. I've said here as well, there's various forms of inspection. Okay, some supervisory bodies come out and actually see you, so be on-site visits. Okay, some just rely on computer-based monitoring. So we do it from a desktop. So they may email you a questionnaire, and depending on how you answer that questionnaire, they'll then decide whether a subsequent follow-up visit in person is required. Okay. So some questions they might ask you: what training have you done? What's your due diligence procedures? Have you made any reports to Sokka, etc. Okay. So depending on how you answer them, they then may decide, okay, we perhaps should come and see this person or see whether they are actually being compliant. Okay. Some of the things the inspectors or compliance officers may want to see, make sure, again, details of the MLRO. So they want to speak to the MLRO. Okay, so make sure everyone in the office knows who the MLRO is, like I said at the beginning of the presentation. They want to see a staff list to make sure everyone's been trained. It's also a good idea to keep any clients who you deem to be high risk on a separate list, just so all staff are aware. Because anyone clearly working on a working papers file of someone who's high risk, they should be aware of that to maybe be a bit more diligent when they put together a set of working papers and maybe look out for anything which is untoward. Okay, so have a separate list of high risk clients. They want to see your customer due diligence records, so your risk assessments, your verifications, etc., etc. Training records, as I just mentioned. I've mentioned here speedy reports. So, I mentioned in the slide on reporting that you need to make that report to Sokka as soon as practically possible. Okay, so they will be looking out, make sure there's no excessive delay in you receiving a report as the MLRO and then making that report onto Sokka. Okay. I would also want to see, any Sokka reports made in the past. Okay. It's just a bit of sales pitch here, which I'll go over. And that's it. Okay. Any questions?